Mr. Patel did I mean, where I think we even assumed he did check the U.S. citizenship box on a Georgia driver's license application. A driver's license is a benefit under federal or state law, so that could lead to a false claim to citizenship. One of the arguments was that under matter of Richmond, it wasn't material because you can get a Georgia driver's license even if you're not a U.S. citizen. And that was a bit complicated. Is it the same driver's license and all of that? But I mean, then the 11th Circuit comes in and says, we don't think matter of Richmond is right on materiality at all. We don't defer to matter of Richmond. Materiality isn't an element of a false claim to citizenship anyway, which is just a very fun little side holding in Patel that nobody ever talks about because the Supreme Court didn't grant cert on it. So in the 11th Circuit only, matter of Richmond's second materiality component is not an element for false claims to citizenship. And in the en banc decision by the 11th Circuit, in the very last page of a 50-page decision, they say, we don't disturb this. Then the Supreme Court didn't grant cert on that. So I guess that's the law, but not everywhere because the Supreme Court didn't grant cert. So with Patel, though, the big issue was, is he the way the Supreme Court said is he eligible for adjustment of status? He's not if if he's inadmissible for a false claim to citizenship. And the Supreme Court said, 11th Circuit's right, we can't even review whether he was inadmissible because it was all tethered to his adjustment of status application. And adjustment of status is one of the 5 forms of relief listed at INA Section 242A2B that jurisdiction is stripped from reviewing factual issues. Other reliefs are adjustment, non-LPR cancellation, regular LPR cancellation, 212H, and I want to say voluntary departure. So those are the 5 forms, I believe, and I'm not sure on VD, but I'm pretty sure, that are listed at 242B. So a pure factual finding tethered to those forms of relief can't be reviewed by the circuit. Now, we think that's wrong, as did Justice Gorsuch in the dissent, because it wasn't a factual issue. It was it wasn't even a relief issue. It was a pre-relief issue. Is he inadmissible in the first place?
The legal issue. It's illegal. It's not a factual discussion.
Well, it was a factual dispute because the IJ also found Mr. Patel not credible.
Do you think that was the biggest factor in that? I mean, you can't
If he
really
was
answer. That's
found credible,
yeah.
if he was found credible, then the IJ would have had to agree that he didn't mean to check the citizenship box.
Yeah.
And then, assuming the 11th Circuit doesn't blow up the first Richmond element, which it seemed primed to do in a footnote, to be honest with you, then it wouldn't be an intentional false claim. And then he probably wouldn't have been inadmissible. So if you assume him credible and you assume there's no factual dispute, Mr. Patel very well might win and Patel doesn't come out the way it does.